counsel and the assistant state attorney. Want to state for the justice?
Christine Brown on behalf of the state.
Camille Smith on behalf of the state. Good morning, Raven Liberty on behalf of Jamell Demons, who is present.
Good morning, Your Honor. David Howard on behalf of Ms. Bennett. And I feel I should say good evening with all those announcements. Stu Allison Melly, and also President of the original Hope Studio Chef. Great. But I know we're a little early for a status conference, but I believe we have a little problem that I need assistance from the court. We started the deposition of the Trevon this morning.
Who is Mr. Glass?
Mr. Glass is a named witness at the state on the tape. It's the witness that they gave us the new address just about 2 weeks ago, or a week and a half ago. We'll take it there. As we were meeting this morning, when I say meeting, the defense team with me, we ran Mr. Trevon Glass criminal record and found that he has a pending charge up in Indian and that he has a lawyer, according to the docket sheet. He attempted to reach that lawyer by the name of, I think it's Justin Barenborg, B-A-R-E-N-B-O-R-G, from the Public Defender's Office out there. He was not in, but his secretary, which I believe her name was Julie. I think it was Julie, but I'm not positive. I really wasn't paying attention to her name. But wanted to speak to him because his client was being deposed, and she indicated that no one gave her notice about the deposition and what happened. When we started the deposition, I asked him if he has contacted his lawyer because he may have a Fifth Amendment privilege dealing with some of the questions. He said he did not. I asked the state if they contacted his lawyer and was advised they did not. And I then advised the state that I think ethically, under the rules, I can't proceed with the deposition. And Mr. Glass asked me, do I need his lawyer? Do I need my lawyer present? And I advised him that we cannot give him legal advice on this. I immediately stopped the deposition, and then here we are in front of you. I think the state is obligated and should have contacted his lawyer under the rules and what have you. We do plan to ask numerous questions that could affect his case up there. I said, let's stop the deposition to inform the court of this issue. Here we are.
Good morning, Christine Brown. The witness was able to speak with his public defender. The witness indicated he wanted to go forward with the deposition. He could raise any Fifth Amendment claims as necessary. There is no discoverable information that could come from a pending charge other than whether or not any promises or anything have been made to the defendant by the state in exchange for his testimony, of which there have been none. So that would be the only area of inquiry that would be reasonable under the facts and circumstances of this case.
Well, if they told us they contacted his lawyer, we wouldn't be here, we would be in the deposition. I don't know what the secret is, and wasting time, quite candidly. But with all due respect, we do plan on asking questions because we believe one of the crimes deals with moral turpitude. And I don't know who is going to invoke or tell him whether or not he should or should not answer. Certainly we can, and I believe the state can. So if the attorney is available during the deposition, fine. But the first question I'm going to ask him is, do you want to waive your right to have an attorney to decide if you have a valid Fifth Amendment right on any question? Yes.
Chair, with regards to, I don't know how the crime of law to that well-defined area of the law, the crime in question is resisting officer without violence.
That's not true. It's also interfering with the execution of a search warrant. The other can't.
Serving and executing a search warrant, which is a misdemeanor charge.
Under Florida statute 19.15.
It's an obstruction of justice, and it doesn't matter if it's a misdemeanor or a felony. And under the discovery rules, we have a right to inquire about anything that may lead to additional impeachment evidence. So when they say it's only resisting arrest, that's what they told us yesterday, but that we have found out that that is absolutely incorrect.
And just that representation is also incorrect. I filed a supplement yesterday. I provided the defense with the information for Mr. Glass's case, which includes both counts, so they were advised.
So when was this information filed?
Yesterday, Judge, which is when the witness showed up.
Sorry,
Yeah.
the charging documents. When was that filed?
And again, just to remind the court, this is the witness that was previously uncooperative and failed to comply. We did a random search about 2 weeks ago, found that he had been arrested. The information was filed on June 19th of 2023. So fairly recent. Yes. Very fairly recent. I believe all he's had is an arraignment so far with the public defender. Again, this is not a witness, is also from Bear Relief, so he's not from Broward County. He traveled yesterday, came, he was supposed to take his deposition yesterday. He got pulled today because of scheduling and conflict. And I would say that while the defense is certainly entitled to inquire as to areas of bias and impeachment, they can't utilize the deposition to violate a witness's Fifth Amendment, right. And I will say that the witness himself can invoke the right without his attorney present. He's chosen to go forward at any time of the deposition where he chooses that he may want to speak with his attorney. He can invoke that right, and that right belongs to him and him alone. So I don't think we need the court's interference at this moment. I think we should look at that position.
Thank you. Anything else you want to share with me? No, sir. What's the relief that you're seeking?
I'm seeking to postpone this deposition so that he can have his attorney present. He's a young man, and for him to decide what questions may or may not incriminate him, with all due respect, it's foolish to believe he knows that and the ramifications. And I cannot, nor can the state, advise him of this. What they should have done, with all due respect, if they contacted him since we've been waiting, is have him on standby and listen to the depo. And put him on a phone. That's all. And I think the information they sent us is dealing with a grand theft and fleeing that I have no idea what that is.
Well, that's incorrect. It's resisting without violence.
What time did you send that? Because I don't check.
And thank you yesterday, upon your request for us to provide you with the prior convictions, which I did. I indicated there were 2 prior felony convictions, and I also provided you with the information.
The bottom line is he doesn't have his lawyer. And I think ethically, I have to bring that to the court's attention. And I think it's negligent on part of the state not to notify his lawyer until we're starting the depo. And it's absolutely foolish for the state to come in here and say he can invoke his right anytime he feels like it. That's why you have a lawyer.
Judge, just for the record, this is a defense deposition where they're proposing the witness. And again, the state's position is that the witness himself needs to invoke that. The state cannot give him legal advice. Just as the defense indicated, they cannot. So it would be for the witness to invoke that regarding his questioning. And the the defendant is clearly indigent. He has a public defender. His jurisdiction is solely in Barrow County Beach. They want an in-person deposition. Surely that public defender is not going to travel here. But the remedy, of course, is we'll ask him and see if he's available to appear on Zoom. And that's a remedy. We would ask that it not be suspended beyond today because we intend to call him on Monday, as the court's aware. The state intends to rest next week, so we don't want to prolong or delay this deposition more than it's already been delayed.
Thank you. Anything else?
No, sir.
All right, I'm just giving you a little bit of time. I need to take a look at it, and although nobody's sharing any cases with me, correct?
No, haven't had time to do research or anything provided from defense on this issue.
My thought process is that defendants individually raise the right to a lawyer all the time. And they do it when they're the suspect of the ongoing criminal investigation, as well as when they make that decision and they're advised that they're Miranda rights and they waive them without lawyers being present, and they do it all the time. So I don't know if how going into something, what's the date of the charging document? Not you told me that June 2023, but the alleged incident.
Oh.
Judge, it's on or around the end of May 30th.
2023.
Correct.
Some several years after the incident in question, right? We're
Yes.
looking October 26th of 2018.
Yes.
Almost 5 years. All right, so in any event, since nobody provided you with any case law on this, I'll take a look. I don't know what rule you're saying, with what rules the state is violating. You said they're in violation of the rules. What rule are you?
I think the Florida bar rules provide that when you know that someone is being represented, this case is a surprise to me.
What the rule number is?
I'm sure that I don't.
So there's been no filing of any notice of appearance on behalf of the witness in this case to give notice to the state on that, which plenty of other witnesses have done.
All right, just give me a few minutes. I'll take a look at it. What about the other motion? Was a deposition supposed to be taken to your expert? Was that done?
They started yesterday, and the state is providing him some additional information, and I think they're going to set up another Zoom hearing on.
Hearing or deposition?
Pardon?
Zoom hearing or deposition?
Deposition.
Yes, Your Honor, we had to bifurcate it. The defense expert indicated that the information that was sent to him by defense counsel was corrupted, so he wasn't able to actually review any of the information to give a valid opinion. So I have to resend him all of the information so he can review it this evening, and then we'll continue with the deposition tomorrow.
How about there's the state's motion for a jury view. We talked about that as well. It's supposed to be separate. Are you still going forward on that motion?
Yes, Your Honor, the state would rely on the written motion. Your Honor's recollection of the testimony and argument that was made in open court as to how it would benefit the jurors. It is separate and distinct from the other items. In fact, the state would submit that the state could offer the entire car into evidence because it is then preserved. It has been the same condition since it was initially put forth. And there is no limitations in the evidence goes to the size of the piece of evidence. If it doesn't come in through the courtroom doors, Your Honor, the state would submit that there would have to make arrangements for the jurors to be able to view the item of evidence.
I did file a response, Your Honor. Were you able to read?
Yes, ma'am. I'm sorry. Anything else?
I would just add that we have yet to view the car ourselves. We're supposed to go see the car this afternoon after court. But as I set forth in my motion, I believe it's overkill. The witness testified to the specs, the measurements in the car. We actually have photographs that have been moved into evidence that have measuring sticks that clearly show you the distance of the car. Her proposition that we need to see the car so that they can see the purview, I guess she's planning on the jurors sitting inside the car, which makes no sense because we They don't have the same measurements as the decedents. Moreover, I'd like to point out, we don't even know where the decedents were truly sitting because there are no crime scene photos that actually show them being in the car at the hospital. All the pictures that we were shown are of the decedents, the car being empty. So I would even argue the proposition of she's trying to say this person's sitting here and this person's sitting here. There's no actual evidence that that's how they were sitting.
All the more reason why it's important to be able to see the car and the defects therein. Council makes a great argument.
And I also argue it's a biohazard.
So in terms of there's never any indication that there was sitting in the car whatsoever, we'll get out of being inappropriate.
Then you make my point, we have enough pictures that have been moved in. Which much of the theme of this case is overkill, we need redundant. They don't need to see the car to get the understanding of the size of the car. I think we got that with the measurements and the pictures.
Anything else to roll down?
Yes, sir.
Thank you. Because of the motion tonight, I don't think it's necessary to have a review. I don't think it's essential. They'll have the photographs of the vehicle in question. I don't think it's going to assist the jury to any great degree in analyzing the evidence. So, respectfully, the motion is done. What about the motion to compel?
That's the deposition of Mr. Glass that we are working on.
I thought you were-
Oh, the other one in terms of the evidence,
Right.
or from the expert. I've asked for any demonstratives, anything of that. During the beginning of the depo, he did discuss that he did create documents and files that were shared with defense counsel on a different area of expertise with regards to cell phone mapping and things of that nature, but he will not be offered in that specific area. So if there is going to be an order limiting his testimony where he cannot talk about anything on cell phone mapping or anything on that, then the state wouldn't be seeking any of those additional materials. However, he also indicated he had taken screenshots and things of that nature during the course of his very unscientific, as he admits, testing that he has done in this case. So I'd be asking those to be turned over forthwith. And then any others that come up during the course of the rest of the deposition.
So he's going to be used, I know there was a change, I guess, in what he was going to be used as an expert. I know he's gifted and has various expertise. And so at some point in time, you advised that all of who's retained to do one type of examination, and was going to be doing something else just with the stellar. Is that saying?
Well, none of it's celebrated. It was based up, she plans on introducing, I'm guessing the state attorney is planning on introducing Apple Health data. 2 weeks ago, we were provided a case out of Wisconsin, the jurisdiction of Wisconsin, regarding lay people testifying to Fitbits. So at that point, if the state's trying to bring in this data from the health app, I thought it would behoove us to get somebody to actually test it. We did start his deposition.
Can I stop you?
Yes.
So this expert, his name is Larry Daniel.
Yes.
He's going to testify as to the health act.
Yes.
And that's the area of expertise. That's the only opinions he's going to be offering is regarding the health act.
Yes, correct.
On the voting question. Right.
Yes. I know the state attorney did get in for almost 2 hours other areas that we were not planning on introducing him to, but yes, if we want an order limiting his testimony to only the health app, that's sufficient with us.
And then he still would need to turn over any of the photos or screenshots that he indicates he took as part of his testing that he did, and any of the other information on that.
Regarding the health act.
Yes, regarding the health application.
And she's free to inquire if he has it, and just as last night, he sent over the information that I provided to her because he had updated his CV unbeknownst to me. We got it to her as soon as it was given to me. So we're not trying to ambush her or keep evidence away. If it's there, we'll give it.
So just do a short order indicating that witness Larry E. Daniel is limited to expertise opinions on the health act, correct? That's what we're talking about. And that any and all things that he used for photographs he intends to use or tests that he's done, just turn those over. I would think counsel would need those sometime before the depositions begin. So whatever he has the results of his examination or whatever he's okay, to discuss, just turn it over to the state, right?
Right, still subject to a downward objection. Potentially a downward objection once I finish the deposition, because the witness himself that it was an unscientific testing that he was doing. So if it's just an anecdotal testing, not based on reliable data on that, the state would be raising that.
So what's the state indicated that this witness is being called because there's a belief that you were legally held back to something to the jury. What is it that you're being held back for?
So if you're on the defendant's iPhone, there is a section in which it's indicates steps taken and the time frame in which those steps are taken, as well as the GPS distance for those steps that are on there. That is coming from Celebrate, not from the phone Apple phone app as you look at it on the phone itself. What the defense witness was trying to do is to try and recreate some sort of experiment, but with no control. He just took two phones and put them in his pocket and walked around his house for a day. There is no validation, he didn't count the number of steps, there's a number of things he didn't do, which raised concerns with the way in which that experiment was conducted. So that's the state's downward objection, that it is not done appropriately, it is not able to be validated or tested and verified in any way, shape, or form.
There's a little bit of irony here, being that the whole reason we have to do it is because the state has given us a case that says a layperson can testify to the Fitbit application. So in this case, it's not Fitbit, it would be the iPhone, and I guess the information taken from Celebrate, so the order, I guess, is going to have to read that he will testify to the Apple Health data downloaded from the Celebrate application, so it can be really clear as what he's testifying to. The whole purpose of having him do the testing is he is an expert in this field. He is doing testing on it. However, it's to counter her introduction, the state's introduction of this evidence through a lay person. So it's a little problematic that you want to file a Daubert motion against our expert while you're trying to present the same testimony through a lay person.
So I understand what the issue is with you agree that it's limited to this health app, and so that's a short order. And his testimony is limited to that, and that you're going to provide counsel the documents and whatever these testing is conducted or whatever he intends to use prior to it. I'm not interested in $1. There's no motion like that in any form. So I'm not interested in that. We've had issues with $1 that are a speedy trial demand, and we're in trial. So I don't know how we'll have to cross that bridge when we come.
Fair enough, Judge.
You want to just, you want to give it out and then, there is a associated, predicate issue, which is we interposed an objection to the admission of this evidence. There's been reference to an out-of-state case regarding the admission of Fitbit. This one is not Fitbit. And two, the law in this jurisdiction is clear and unequivocal that in order to introduce information derived from phone application technology, such as GPS, and in this case, a pedometer, that there must be a witness to authenticate it as far as its reliability is concerned. The out-of-state case, with all due respect, missed the mark entirely. They said Fitbit's around for a long time. We don't have to explain to a jury what Fitbit is. They understand what it is and they believe it's reliable. If a jury believes something is reliable, it's of no moment. The reliability has to be established as a predicate to the introduction of the evidence itself. So this issue really becomes moot if the state is prohibited, as the law requires, from introducing this evidence absent somebody to testify as to the technology related to the pedometer and that fact that the information derived from application of that technology is reliable. And,
I assume you filed like a motion to this effect?
well, I gave the court cases, and we have been, because trial is a fluid process, presenting the court with case law as we go along. This motion would not, I guess, be ripe until the depo has been concluded. So I will provide the court a written motion so I can cite to the cases that I have already provided the court. And I think the case is referred in that case to a GPS map, which is just as prevalent and common in usage. And in that case, the DCAs, I think of both the fourth and the first, overturned the conviction, reversed on the basis of introducing it without a predicate authentication that the technology is reliable. So I'll provide the court something.
That would be wonderful, rather than speaking in a vacuum, not citing the actual cases on that.
Well, I provided you the cases, I provided the court the cases, so there is no vacuum. I gave you both. It's in a folder when it was. Anyway, that's it. Thank you.
And Judge, when Your Honor asked for some guidance, I'm going to provide court counsel with printed. I didn't want to print while everyone was talking. Florida Statute 914.04, which is witnesses person not excused from testifying essentially because they're testifying pursuant to a subpoena, so they're being compelled to provide testimony. And also Lee versus State 318, Southern 2nd, 431, 1975, 4th District Court case.
318 Southern 2nd.
431, 1975, 4th District Court.
What's the proposition? Are you going to print it?
It's in regards to trial testimony, but it's essentially the same, discussing a witness's Fifth Amendment right versus the defense's right to impeach or bring out bias testimony.
Are you printing out those cases now?
Yes, Judge.
Thank you. And before I let you go, I was approached by Judge Bonnie, indicated that he's looking for services in Ms. Bradley on July 19th for a half a day. He told me we needed others 250 jurors that requested and subpoenaed to be here on a different case. And so he's our administrative judge, and he wants Ms. Bradley for
He's administrative. So we defer to court schedule.
it's honest, but you know, they're in the session in the morning of the
We're not going to be in session in the morning of the 19th.
and I don't know how long it's going to be. I'll have it, he said 250 jurors.
Yeah, I was not consulted on this, and make sure it's more out of my schedule and my availability on that, so I'm at the court's pleasure. Wherever it goes.
There is one thing I would like to suggest is that if we're talking about 250 jurors, that we not be placed in the position of coming and sitting here at 1 o'clock and waiting to see if it's over. So maybe we just strike the 19th altogether as opposed to waiting around to see how long it takes.
I think we could jurors are sequestered at that point. If we're in that there, being settled on for a hotel, and just sit there.
If the jurors are sequestered, then it's pretty much moved. We'll be hanging around regardless. All right?
I don't think the jurors will be requested on the 19th. You're thinking, based on the schedule that we're talking about, the 17th and the 18th would just be starting our event, so there would be no sequestration. Thank you.
In your today, to continue the deposition is client. Oh, I'm sorry.
Just give me a case.
Okay.
He actually gave me a statute, not a case, but I see the
I
case.
did both, Your Honor.
Let's get back to work, please. In this, defendant, this counsel, and the assistant state attorney, I had an opportunity to review the case, leading the state, cited as 318 Southern 2nd, 431, as well as the council provided me a copy of statute 914.04. Anything, any other argument?
Just briefly, Your Honor, my review of this case tends to suggest that the state was working on the behalf of the defense, in that it indicates that in face and relevancy and materiality evidence the following substance is considered. Could a witness who has operated as a paid opponent for the sheriff's office of numerous drug buys, and who between one of these buys and its prosecution is himself charged with a crime of robbery which is pending, and that he is called by the state to testify in the drug case, be materially influenced or biased in giving of his testimony by the fact of his being so charged? And the next paragraph begins, the answer is clearly yes. And it goes on. And there are several other instances where essentially this case stands for the proposition that while the fact of being charged itself, if inquired into, would have some Fifth Amendment implications, and it would have to admit being arrested. And also where the details of the crime itself may not be relevant, they go to the witness's bias. And in this particular case, where somebody is unable to be found and all of a sudden makes himself available to the state as soon as he's charged with a crime, that would even more implicate the fact that he's trying to curry favor. And we are certain that we have the right to inquire into these matters. And the question is whether or not we're going to leave him unprotected without a lawyer while we do so. That would be our decision.
Thank you. Well done. Anything else?
That's it.
So,
No, nothing.
all right, so my thought, this case.
Yes, there is one other thing. You asked me about the rule 4-4.2, communication with person represented by counsel. In representing the client, the lawyer must not communicate about the subject of the representation with a person the lawyer knows to be represented by another lawyer in the matter, unless the lawyer has the consent of the other lawyer. That is basically the situation here.
As I stated before, there's been no current file, this witness filed in this case.
It doesn't have to be.
It matter.
It doesn't have to be. They know that he's got pending criminal charges. They know he has a lawyer, and the discovery rules for deposition are pretty open as to what we may ask that may lead to relevant information. And under the rules, that's why we stopped the deposition once we learned that he was represented and that he had no contact with his lawyer, nor were we advised, according to his secretary, that they even knew he was going to be deposed.
And just for clarification on the record, this is a defense depo. He's in Broward County pursuant to defense subpoena, not a state subpoena. If your honor recalls, I represented when the state served him with a subpoena, he failed to appear. He indicated to me he was not coming to Broward County. Subsequent to that, over a week or so later, the defense served who they represented to be his mother via substitute service, and that's why he's here. And further, the state, myself, Melissa Bradley, has communicated with the witness in regards to any facts on his underlying case. As your honor is very much aware that there are multiple cases where witnesses may be charged with a crime. It doesn't preclude us from speaking with them at all. It precludes us from discussing facts that we know would be incriminating and then later trying to seek it to use against that individual or any other violation of attorney-client privilege, which again, is here because of the defense subpoena, and we've only communicated with him in regards to the fact that this particular case, which your honor has recalled, occurred 5 years prior to his current pending case, and furthermore regarding scheduling of him being here in Broward County for purposes of the defense's deposition.
This is a rule that you're citing. I haven't seen it. Can you, do you have a copy of it? What rule is this? Rules of Florida Bar?
Yes.
Move. What did I do? What?
4.4 dash.
4 point what?
What? Sorry, Judge, I just lost it on one second. I think it's
4.4 to communications with person.
4 point what?
4.4 to plan communication represented by council. You said 4, and then you said 4 to.
I lost the one.
4.4 dash 4.2,
4.4.
4 dash 4.2. Communication with person represented by client.
Yes, that's the section.
4.2. All right, Council, I've read 4-4.2, communication with person represented by council. I see it, and I don't really know or understand how that is going to come about. I see the indication. This appears to me to be a different scenario. He's represented by. I'm looking at the league versus state. It appears to me to be right on point. Council, it basically indicates that they're allowed to do it if he exercises his Fifth Amendment right. That's one thing. If he doesn't exercise his Fifth Amendment right, it's something different, and it's up to the court up there in what you said, Indian River. I'm not really sure which county it is, league, whatever county It's up to them to decide whether or not he should have been advised and whether that gives him some type of immunity. He's under subpoena, he's here. My understanding from the state is he's willing to testify, answer your questions. So I would suggest you proceed with the deposition.
Okay, so you're saying, so it's clear we're not violating any rule, even though we know that he is presently being represented by parents.
I don't, I'm looking at the state case of Levy State. It's an older case. It says, it appears to me to be on point. I understand what you're saying about 4-4.2. I don't know what the circumstances of that are. That is not as clear to me. And my thought is the deposition should proceed.
Pursuant to your rule, we will proceed. And that's all I wanted I actually wanted to protect ourselves in not violating the rule of professional ethics.
Let me ask you this though, if there's, I don't know what else it's going to be, but my understanding from the state is that this incident happened allegedly sometime in 23. That's what the charging document against the witness suggests. So it's approximately 5 years, almost 5 years, not quite 4.5, I guess.
I don't think that's material because it deals with his credibility as he takes this stand Monday, basically.
You can ask him anything you want about whether there's any charges, deals that are made, anything that goes to bias.
I understand.
I don't think we have any objection to any of those things. If there is, the state should let me know. But this one case also says, oh, that's fair game. And that's why the case got reversed, because the judge didn't allow it. So it seems to me that that's...
Well, the problem is, so Your Honor knows in a nutshell, we do plan on asking him about that case. And I don't know how he can make a educated response on whether or not it's a valid Fifth Amendment privilege and refuse to answer it unless he consults with, as we know, his lawyer. As long as the court says go ahead, we're covered, but I most respectfully disagree with that. I don't think the state can advise him of any of those questions. And if he refuses to answer those questions merely since I don't want to answer them, we will certify those questions. And I don't know how anyone will determine whether or not it's a valid Fifth Amendment right privilege without his lawyer. But we'll find out. Fair enough.
Ask the question away. I'm here all afternoon.
You're smiling and you probably won't be when we're back here in about 20 minutes. I don't want to do this step over here. I don't want to bother this courtroom. There's no reason. We have a court reporter waiting for us. We're going to walk right over to the state attorney's office like we do with every other witness and proceed.
All right. Thank you.
And if that's all the step. Calculator based upon line.
Thank you, Judge.
Whatever it is.
Have a good one.
You got one?
Yes, sir.
Thank you for your time.
Thank you all. Who's in the back there? What's your name?
Did you miss us?
Yeah, who are you?
My name is Natalie. I'm an intern.
Come on up. You both interns?
I took out my brother for the day.